Okay, abusuya be makwa abasonko so ereba POG Media so abusuya yembunra yensem breaking news bi aba eno ene ya projected dey ato ye screen no enchen dey amamo no. Chief Justice Torkornoo asked the Supreme Court to stop the committee probing her alleged misconduct from investigating or participating in the removal process. Abusuya osoro mesa ontwen. Sa 5-member committee na eche say yatina eche say omoba be investigate Chief Justice Torkornoo the lives of Tsikata mo tadia sorry mo Oliver Bakavama o mama no one san kwofo ni na o case into ono so e na esi form osemasa mo de mo de be yem no mente ase kra into ono so asi o mabusu aba akonso ne mo mi ready eno so nkan Chief Justice Torkornoo sues members of the committee probing 3 petitions for her removal abusu ya osono mame. There is interesting moment ahead. Any asam keto. Akrabusu we any breaking news ho ayen so ya de bre. Mom yan na yan konkoti ensema e course so e political highway ni so. Medamase.
Quite closely here on Ghana Tonight over the last few minutes that we got this information. So this is the latest development regarding the process that is ongoing. Looking into the 3 petitions against the Chief Justice. As we do know, that committee, the 5-member committee that was set up, has started hearing the petitions. As we do know, was submitted and also prima facie case established against the Chief Justice, leading to that suspension. Now, last week, we got that information of this 5-member committee starting the processes for the hearing of these petitions. What we're learning today, this evening, is that the Supreme Court is to hear the suit filed by one citizen, Theodore Kofi Atta Korte. That's the name. Theodore Kofi Atta Korte, seeking to restrain this 5-member committee inquiring, probing the petition to remove the Chief Justice, Torkornoo. The plaintiff also is seeking a number of things from the Apex Court to suspend the operationalization of the suspension warrant by the President, John Dramani Mahama, against the Chief Justice. And we understand the motion is supposed to be heard tomorrow. Dennis Barberi Wadam Esquire has been studying this information that we got exclusively here on Ghana Tonight, and is joining me in the studio right now to get an understanding of how things are playing out. Dennis, what more do we know of this latest development?
Well, Alfred, a lot seems to be happening in this space, especially as regards the petitions that are seeking the removal of the Chief Justice now suspended. The latest twist that we're getting to this is the fact that there's a pending suit which is going to be heard. The injunction bit of it will be heard tomorrow. Mind you, an injunction will have to be mounted on a substantive suit. So that means that there's a substantive suit that is before the Supreme Court and is seeking quite a number of reliefs. But tomorrow, what's going to happen is that in addition to that substantive suit is an application for an injunction to stop all the processes that are ongoing now by way of the hearing which is ongoing as regards the petitions that are seeking the removal of the Chief Justice. Now, what's interesting about this particular suit or the injunction is that it does not only seek to stop the process ongoing, it also seeks that an order be given so that it's in respect of the suit itself, that everything that has been done by way of this process, right from the establishment of a prima facie case all through to the establishment of that committee that you see the membership here, and together with the hearing which is ongoing, be declared null and void.
I see. Now,
this is an additional layer to what we have been dealing with so far, because recall that there was also an attempt to stop the process, and the reason was that that is in respect of the Vincent case. For his argument basically was that when the president received the petitions, the law required that the president should have sent the petitions to the Chief Justice for her to respond before the prima facie case be determined by the president together with the Council of State. And to the extent that in his view that did not happen, that was a violation of the Constitution, for which he went to the Supreme Court, subsequent to which he sought an injunction which was denied.
I see.
Now, this application is mounted on the grounds that the role that the president, or the decision that the president is taking in this particular process, is one of an exercise of discretion, for which reason the provisions of Article 23 and 296 of the 1992 Constitution must apply. And in so doing, to the extent that the president is not a judicial officer, the requirement by the Constitution is that there ought to be the publication of some instruments, constitutional instruments for that matter.
I see.
And that because those that constitutional instrument, in his view, has not been published, it's a violation for which the court must intervene. Alfred, if you recall, this is not an entirely new argument altogether, except to say that this is an argument that has now been submitted to a forum that can appropriately determine it. You recall the Ghana Bar Association, in its resolution, one of the key things they did indicate was the fact that they thought what the president had done by way of suspending the Chief Justice was not lawful, and their argument was that the president ought to have come under Article 296 and to that extent published a constitutional instrument to have the matter, before taking that decision of the suspension. That is largely that's the animated form of what we are having to deal with now. But like I said, this has now been put before the Supreme Court to look into it to determine whether or not that indeed is the case. But in the interim, the applicant now is saying that let's put all the processes that are ongoing on hold. Let's put it on hold until the matters that
even with the hearing of this committee that began last week.
Yes.
The applicant is seeking as part of his reliefs.
Yes.
That all of that process should be put on hold.
All of that process be put on hold. So this is it. Because there is a substantive suit to be heard, the applicant is understood to be saying that, yes, I do acknowledge that I have brought before you a matter to be resolved, and that this matter that I have brought before you will take some time to be resolved. However, there is somebody in the mix whose rights will be affected by the outcome of the matter I've brought before you.
Right.
So let's put the processes on hold, if you agree with me, so that at the end of the day, if it turns out that the person whose rights will be affected by this will not be affected, then we can make a determination.
I think Vincent Assefa also made...
Yes, so we need to separate the two things.
Reliefs that he was asking
yes,
in there.
But in his case, his argument was quite different. But of course, the net effect will be the same because both applicants, and I refer to Vincent in that case and then Theodore in this particular one, are seeking to halt the process. And that's why I say the net effect will be the same, except to say that the arguments are substantially different. And like I did indicate using the GBA position on this, this is the leg of the GBA argument that has now been put before the court. But that of Vincent Assefa was the fact that whether the petition had to be given to the Chief Justice before the consideration of a prima facie case, or it could be ongoing before it was given. That was, you recall, that debate in Parliament, that argument in court, where Justice Yoni Kolendi asked lawyer for Vincent to show which provision in the Constitution gives timelines as to what time the petition should be given to the affected Chief Justice for the response. So that was the crux of his matter. But this now has to do with the exercise of discretionary powers and how they should be exercised or ought to be exercised. It is the view of the applicant in this matter that he does not think that the exercise of discretion in even the matters of determining the prima facie case, the suspension of the Chief Justice, and even the constitution of this committee, which is currently hearing the matters, is done according to law, for which he wants the matters determined. In the interim, he seeks an injunction to stop the process altogether. And this will be heard tomorrow, Alfred.
And we have a copy of this suit that Dennis makes reference to. We're going to put it on the screen right now. And Dennis makes reference. That's what you see right there. The Supreme Court is to hear this suit that you're seeing there, filed by a citizen by name Theodore Kofi Atta-Korte, seeking to restrain the Committee of Inquiry probing the petition to remove the Chief Justice, Torkornoo. Now, as Dennis has eloquently stated, the specific reliefs that this applicant is seeking, you see there the defendant in this case and respondent being the Attorney General, specifically the Office of the Attorney General, Minister of Justice. What this plaintiff is also asking for is that he wants the Apex Court to suspend the operationalization of the suspension warrant by the President, John Dramani Mahama, against the Chief Justice. And essentially, then he's talking about the suspension of the... Let's roll it up a bit, and then we'll see. the full details of this suit, which we have a copy of. As you see there, if he's asking for the suspension of the operationalization of the warrant,
yes,
that sought to, in fact, that has led to the suspension of the Chief Justice. What does it mean?
Well, so you know that when the Chief Justice was suspended, that was done in consultation with the Council of State, and that was done with the issuance of a warrant. So to suspend the suspension of the Chief Justice, I always want to use Vincent's words, to suspend the suspension of the Chief Justice, it means that that warrant will have to be suspended.
And that's one of the reliefs.
And that's one of the reliefs that Theodore is actually seeking
for
at the moment.
I see. But Vincent has said for that particular relief he was seeking was not granted.
No, that wasn't granted. And like I did indicate, perhaps it is the view of this applicant that the argument he's now advancing will be superior to that of what the court has already denied. Mind you, the substance of the arguments put before the courts are different. And that's what we need to emphasize in this. Because when you look at this clearly, they make references to Article 23, they make references to Article 296, they make references to the absence of the publication of a constitutional instrument, which they say is a requirement under Article 296 for the exercise of discretionary powers, to the extent that they say the president is not a judicial officer. So the arguments for him, it's largely on that level. So you would find that in his case, he's not arguing along the lines of whether the Chief Justice should have been given the petitions first for her response before the prima facie case or the other way around. His argument is entirely different from what we're having to deal with in this matter. So that's the injunction application that you see on the screen.
And that's what we're talking about right now here on Ghana Tonight. And that's a copy we have also secured exclusively here on Ghana Tonight on TV3. And that's the detail that Dennis has teased out for you quite eloquently there. The Supreme Court is to hear this suit that we're seeing on the screen right now, filed by citizen Theodore Kofi Atakorte, seeking to restrain the committee of inquiry probing the petition to remove the Chief Justice Torkornoo. So the plaintiff is also asking the Apex Court to suspend the operationalization of the suspension warrant by the president against the Chief Justice. And this motion is supposed to be heard tomorrow. So we'll keep an eye on how things play out. But still staying with the courts, Dennis. And that leads us to our next issue. Coming up next here on Ghana Tonight. The full complement of this suit, as you're seeing on the screen, you can find on 3news.com. But coming up next here on Ghana Tonight, we have an update for you in the matter of the Accra Sky Train that never was, and how the ongoing legal processes are progressing. Well, guess what? This is one that we've been following quite closely. Lawyers of the former board chair of the Ghana Infrastructure Investment Fund have told the Accra High Court that their client, Professor Christopher Akuffo, was rushed to the emergency ward earlier today. Now, the lead counsel, Duke Aaron Tsatsu, was responding to Justice Comfort Tasiame's query regarding Professor Akuffo's absence. In fact, whose plea was scheduled to be taken today. My colleague Lord Dwasari was in court earlier today. But then again, let's recall exactly what the Deputy Attorney General, Dr. Justice Adam Shremsai, said regarding this particular Sky Train, and how this is the second adjournment because of Professor Christopher Akuffo's absence. The first, if you recall, last week, the case was adjourned because he was on admission at the University of Ghana Medical Center. Today, they turn up in court, and then his lawyers again told the courts that he was rushed to the emergency ward today as well. The presiding judge had something to say about this development, consistent development of Professor Christopher Akuffo's absence as a result of medical issues. But this is what Dr. Adam Shremsai said on this Sky Train matter. Take a look.
There is an active process. The Attorney General has instituted an active process of recovering, tracing these monies. So I would say that whether you do it voluntarily or not, we will do whatever it takes in the name of the Republic of Ghana to retrieve every pesewa that we can from private hands and restore those monies to the people of Ghana and to the taxpayers of this country. No, the press conference is not. The AG will hold press conference when the need arises. in this particular case, we believe that the issues are already in the public. The new journalists are very much aware of the Sky Train issues. It was first raised in the Auditor General's report, so I don't think anyone is in a doubt as to the facts of this case. So there may not be any press conference on this. But where there's a new case which will require deliberate, thorough briefing, we believe that the people of this country are entitled to know every bit of what we are doing with the power they have given us. So we will hold press conference when the need arises. Right. Thank you so much. Thank you very much.
That's the Deputy Attorney General, Minister of Justice, Dr. Edem Sremsai there. But let's refresh our minds. What are the charges against Professor Christopher Amiel Akumfi? Dennis, what do we know?
We know that he's the second accused person in this particular matter. And it's because of his absence today that the court had to adjourn so that he recovers from the illness that was reported to the court. But we do know that some 3 charges have been preferred against him personally, one jointly with the CEO of the GIF in respect of the conspiracy to commit crime, and this is willfully causing financial loss to the state. He's also been charged with willfully causing financial loss to the Republic. That is just against him personally. There's also a conspiracy to commit crime, which is intentional dissipation of public funds, and also there's a charge against him as regards intentional dissipation of public funds. And this, like you rightly indicated, is in respect of that transaction that was supposed to help Ghana get an Accra Sky Train. We did illustrate how some companies were set up and how GIF was supposed to have partnered a certain company to undertake this particular project with some obligations on GIF. However, it turned out that that particular project could not come to light, even though we had partnered with some $2 million in respect of purchase of some shares in another company that was incorporated elsewhere, which was supposed to be working closely with the original company that GIF had partnered on this Sky Train matter. So, Alfred, basically these are the matters that are in contention, for which reason the good old prof now finds himself in trouble.
Talk about the good old prof, but why exactly is the trial judge not too happy about this development? What does she say regarding the 2 instances of Professor Amiel Akumfi's absence as a result of some medical issues?
Well, so if you recall, the first time they were in court, Prof was not in court, but the first accused person was in court. His plea was taken. So they had to adjourn for him to come today so that his plea will be taken. Then again, the court was informed that just this dawn, at least according to lawyers for Prof, that just this dawn they were informed that he was rushed to the hospital again. This being the second time, the judge made an observation. And this is exactly what the judge said, Justice Comfort Tessem. She says that there is concern over the timing of Prof. Amiel Akumfi's recurring medical emergencies, which appear to coincide with scheduled court dates. I mean, this was something that the Deputy Attorney General, who was in court, also observed and said, yes, since the court has made the observation for them, but it's important to indicate that lawyers had said that by Friday, he would have been well, so that they will come to court. So they were seeking an adjournment to Friday so that he will come for the plea to be taken. But the court granted more than that to Monday. But the Deputy Attorney General did indicate that when they come back on that day, they will indicate how prosecution intends to proceed with this particular matter.
But let's stay a bit further on this. Martin Pebo is private legal practitioner. He's joining us on Zoom right now. Lawyer Martin Pebo, good evening. Thank you for joining us.
Let me access and I'm starting to order based people.
Hello.
Please.
Hello, Lawyer Martin Pebo. We'll try to reconnect with Lawyer Martin Pebo on this particular one, but let's get to know the man we're talking about, Professor Christopher Amiel Akumfi, because last week we mentioned that, because a number of you have also made reference to why he's, in fact, sharing in the same sentiments of the trial judge on this matter about his absence because of medical issues. He's an 80-year-old man, correct?
Yes, he's an 80-year-old man.
And what else do we know?
And it's fair to refer to him as a good old prof. Yes, this is a man who, former board chair, this is the position in in respect of which he's now been accused of some wrongdoing for which he's before the law courts. He's also the former board chair for Public Procurement Authority, also former Minister of State, a former Minister for Ports, Harbours and Railways, former Director General for the Ghana Education Service. He's also the former MPP National Council of Elders member and also a former MPP National Chairman aspirant. So this is a man who has served...
Yeah, people is going to be joining us on Zoom in a bit. Yeah,
yes,
right
so this is a man who has served extensively in the public service. He's also served his party in other capacities and also made attempts to actually lead the party MPP. So he's a man who is well known. He's very popular when it comes to public service.
Okay. People, good evening. Can you hear me now? Hello, Council, good evening. Hello, Lawyer Martin, people, can you hear us? Hello? Unfortunately, we have a connection difficulty to Lawyer Martin Pebble. We'll try to reconnect with him, but let's hear what the Deputy Attorney General, Justice Shamsai, said about this whole Sky Train matter again, and we'll hear Lawyer Martin Pebble shortly. Take a look at this.
An active process, the Attorney General has instituted an active process of recovering, tracing these monies. So I would say that whether you do it voluntarily or not, we will do whatever it takes in the name of the Republic of Ghana to retrieve every pesewa that we can from private hands and restore those monies to the people of Ghana and to the taxpayers of this country. No, the press conference is not. The AG will hold press conference when the need arises.
And some also political highway. So I Chief Justice Torkornoo and also I see a 5-member committee. I say or more babetna. Akunyem no more I investigating. Mamma say on Tiasema, Akuffo no investigating and ne alternate on also Eddie Apako PMO Supreme Court and ya Assam Kitoko winning and some a course of our political highway. So you better say so much penny, Cocoa teaser in some way, Edemai, better say.